now in session. Please be seated.
Thank you. Call the next case, please. May have already called it, but
Yes, Your Honor.
let's get back to it.
State of Tennessee versus Mustafa, Malik, Slater, and Tramell, Rasha, Sparkman.
Thank you. General, good morning.
Good morning. May it please the court, Alan Groves on behalf of the state of Tennessee. I'd like to reserve 5 minutes for rebuttal.
Certainly.
So in this murder case, the trial court granted the defendant's pretrial motion to give the old accomplice corroboration jury instruction, even though the Tennessee Supreme Court abolished the common law accomplice corroboration rule last year. Because the trial court failed to follow binding Supreme Court precedent, this court should reverse. So as this court knows, historically, Tennessee courts did recognize the common law accomplice corroboration rule, which prevented juries from convicting defendants based solely on the uncorroborated testimony of an accomplice. But that changed last year when the Tennessee Supreme Court decided State versus Thomas, which abrogated the common law rule for, quote, all trials commencing after the date of the mandate in that case, which was issued in March of 2024. So obviously we're in an interlocutory posture here. The trial in this case has not happened, so the common law accomplice corroboration rule doesn't apply in this case. The trial court, however, failed to take the Thomas holding, what it called literally, because there was disagreement between the majority opinion in Thomas and Justice Campbell in her separate partial dissenting opinion on whether to apply the holding of the case retroactively in that case. And so Justice Campbell would have applied the holding in that case and not applied the common law rule, but the majority said that that would have been unfair to Ms. Thomas in the case. And it said that it was going to apply its holding prospectively instead. But the trial court really focused on one or two sentences in the majority opinion, where the majority in Thomas is kind of characterizing Justice Campbell's opinion and saying that she would have applied the holding to all pending cases that had not yet reached a final judgment. And so the trial court is thinking, well, that must mean the majority thought the complete opposite and that there's no overlap between the two. But you really have to just ignore the two times that the majority says explicitly the holding is going to apply to all trials commencing after the date of the mandate. You really just have to completely ignore that to get that out of those other sentences and how the majority is characterizing Justice Campbell's opinion. So that's kind of how the trial court went wrong here. And if the plain text of the opinion wasn't enough, if you think about the two fairness concerns that were driving the Thomas decision, they're really not at play here. Because first, the court held in Thomas that it would be unfair to apply or to abrogate the common law rule in Ms. Thomas's case, because that would effectively have lowered the burden of proof for the state on appeal. And it could have satisfied a lower evidentiary hurdle on appeal than it did at trial. Well, that's not at issue here because we haven't had the trial, so you would apply the same standard, at trial or on appeal. The second fairness concern that was raised by the court in Thomas was that it might have impacted the defendant's trial strategy or approach to plea negotiations if they knew the state was not going to have to corroborate accomplice testimony. But here, Thomas was decided in March of 2024. Trial was, I think, set in December 2020. I think it was set in December of 2024. So the defendants had at least 6 months to prepare for trial under this new rule. They were put on notice by the Thomas opinion that the common law rule would no longer apply. So neither of those fairness concerns are really at issue here. And I think the case is really that simple, Your Honors. The court just misconstrued the holding of Thomas based, again, on how it viewed the majority opinion characterizing Justice Campbell's separate opinion. But even Justice Campbell thought that the majority opinion would abrogate the rule for pending cases that had not yet gone to trial. That's pretty clearly stated in her own dissenting opinion. So on appeal, the defendants just raised a few arguments that I want to briefly address for the court. One is that I believe Sparkman says that if the trial court's error was so bad here, why did the state file a Rule 9 motion for interlocutory review instead of a Rule 10 application for an extraordinary appeal? And we pointed out that this court has held that the usual and preferred practice is for the state to first seek interlocutory review by permission from the trial court in a Rule 9 motion. And if that's not successful, we usually will pursue a Rule 10 if that's appropriate. There's nothing in the rules that would require us to seek an extraordinary appeal first.
Rule 9 is basically the trial court has gone slightly off the rails, and Rule 10 is they've gone completely off the deep end. Is that pretty much the legal definition for those two?
That might be a fair summary, Your Honor.
Yeah.
There's some factors in Rule 9 that we usually walk through, and we did so in our Rule 9 application. This court granted that, and so that it's kind of a moot point at this point whether the court properly granted the Rule 9. We think we followed proper procedures there. Another argument that's been raised is I think Sparkman argues that this court's decision in Hughes from last year somehow muddies the waters, but we don't think so at all. In Hughes, the case was pending on direct review. So the trial had already happened. The case was just pending in the appellate pipeline on direct review, and this court said, we do need to apply the old accomplice corroboration rule because we're not talking about a trial that commenced after the date of the mandate of Thomas. The trial had already happened. It was just pending on direct review. That's a proper application of Thomas. So there's nothing about Hughes that was wrongly decided, and it doesn't muddy the waters. Slater argues, if I'm understanding his brief correctly, that Thomas should just simply not apply in cases where the state relied on illegally obtained evidence. And I'm not exactly sure where this is coming from because, for one, the record is not really developed at this point. We're just in an interlocutory appeal, so a lot of the facts that Slater is citing in his brief just aren't in the record with respect to the different confessions and statements by co-defendants that were made. And in any event, I'm not really sure how that would be relevant to whether Thomas applies in this case. The Supreme Court's holding seems to be pretty clear to me, and I don't think it turns on whether evidence was illegally obtained or not. And then the final point I just want to raise or respond to from the defendant's brief is that there's a suggestion that the trial court might revisit its speedy trial ruling if the state prevails in this appeal, because there was some discussion in the trial court about whether it would be fair for the state to prevail on the motion to dismiss the indictment. The defendants had raised a speedy trial claim if we could go forward on the trial without the accomplice corroboration rule, that common law rule that requires some additional corroboration. And the trial court had already denied that speedy trial motion, but it seemed to be waffling about whether it would reconsider that if Thomas did apply here. And that's all kind of hypothetical at this point because that motion's been denied. The defendants didn't seek interlocutory review of the speedy trial motion, so it's not really before the court right now. And you can't seek interlocutory review of a speedy trial claim. We've pointed that out in our brief. There's Supreme Court precedent that says that. So if we prevail on this appeal and it goes back down, the defendants could renew that motion if they wanted to, and the trial court could rule on it at that time, and we could cross that bridge when we get there. But all we're asking this court to do is to reverse the trial court's order granting the defendant's motion to give the old accomplice corroboration jury instruction. If there's no questions, see the remainder of my time for rebuttal. Thanks.
All right, thank you, General.
Good morning. Douglas Bates of the Hickman County Bar, somewhat the sponsor of this morning's docket with two cases. I'm not going to use close to 20 minutes, so I'm going to tell a story to start.
We like stories.
Good.
Go right ahead.
I was not a very good hitter in baseball when I grew up. And when there would be runners on the base, I'd be going to the batter's box, excited I was about to get a hit. I'd look to the coach and he'd give me the bunt sign. And I'd know I'm about to get out. When the court took this Rule 9 appeal, I felt like that kid again getting the bunt sign knowing I'm about to be out. I do want to add just a couple things, though. I respectfully to the state, the motion to dismiss that was heard in August, the same time the motion to hear the pre-Thomas or post-Thomas corroboration instruction was heard, the trial court asked me, what is the prejudice of this delay? And that's when I said, well, if this case were tried before March, you'd have the corroboration rule. The state later on made virtually no importance on the corroboration rule. That the state said, oh, this is not an important issue at all. There's going to be so much corroboration in the case. But that's where I understand where the court, perhaps I misapplied Hughes that says prospective cases. Yes, it had already been tried. But that, obviously it's not before today's court, but the state might be seeking what could be a Pyrrhic victory where they have as a ruling from this court, yes, the state will have the benefit of an over 4 or 5 year delay because the corroboration rule has been extinguished, and the trial court then might take that up on a renewed motion to dismiss for the speedy trial claims. That's my argument, Your Honor.
Well, even if we send it back, you still have that argument on direct appeal should your client be convicted, correct? I mean, there's nothing about what we can do on this Rule 9 that would take that away from you.
It will make, as a matter of law, prejudice
Right.
in the defense position.
I get that point.
When was he indicted? Murder was at 2015, you know?
2020.
2020.
And I suppose your initial motion for speedy trial was based upon the delay in bringing it to prosecution?
Mainly from the arraignment to the trial date. That I don't believe there was there was no setting until the 2024 trial date. Not the pre-indictment delay is not the basis. Based on the state's investigation did not reveal it. Candidly, there was not much delay between the investigation and the arraignment.
You would agree, it sounds like, that the majority opinion is pretty straightforward on this question.
I think the state did a noble job finding the one area
Okay.
of perhaps grayness, but yes, the majority opinion said it attaches to all trials, and trials are not procedurally the same. Just if a case comes out of the grand jury, that doesn't mean it. Trial means a jury or a trial court, if a jury is waived, is hearing the case, and jeopardy attaches. It's good to see you, gentlemen. Thank you.
Thank you, Mr. Bates.
Hey, thank you. Any
Are
rebuttal?
you waiving your rebuttal?
Oh,
Oh, we got
There's more? I'm sorry. I'm
Two for the
sorry.
price of one.
My mistake. I apologize.
and Mr. White, I understand you flew in this morning just for this argument.
I flew in yesterday evening, Your Honor,
Yeah.
yes, and I fly back
Where
out
are you
tomorrow.
now?
I'm in Coeur d'Alene, Idaho,
Okay.
which is North Idaho.
Like the World Jamboree in 1967, Boy Scouts, Coeur d'Alene, Idaho.
Oh, my
Well,
goodness.
then you know how pretty it is. You probably still remember it. It's a fisherman's paradise and definitely an outdoorsman's paradise.
Well, I doubly apologize for almost after going to all the trouble to get here, and then I tried to skip over you.
Oh, you know, it would have fit. It probably would have caused some genial laughter over
Are
there.
you still involved in the case in Hickman County, or have you been replaced?
I am at this point. I've learned through previous error that you cannot withdraw from an appeal until a certain point, otherwise face an ethical decision. So I am kind of stuck in this. We were supposed to try this case back in August of 24, and at the 11th hour, the state came forward with an appeal. That was a correction from what the general relied on, but again, he wasn't involved at that point. I'm the only attorney who's been involved since the initiation of this case. The state's been recused and replaced. The co-counsel has had multiple attorneys come back in. Yeah, the due process and speedy trial issues are still addressable on the appeal. You know, it took over 18 months to get a motion to suppress heard. And some of it was COVID, some of it was transition, some of it was just passing the baby because they had easier fish to fry. And then if I just want to jump into my argument, you know, they are getting the benefit of the delay here. I mean, a 5-year delay to trial that was primarily caused by the state, 5% of it maybe was caused by the state. I can't remember if back in 2020 I agreed to a continuance or not because I didn't think it would go this long. However, there were two motions, there was multiple motions brought on that day, and one of them was the validity of this evidence, since it is all illegally obtained evidence. Now, what we had here was we had two hearings really close together, and I can't remember the overlap of them, but what it came down to was we had two separate officers. I know y'all read my brief, but I'm just going to keep the record going. Two separate officers from two separate agencies, one from the Tennessee Bureau of Investigation and one from the Hickman County Sheriff's Department, go into a room, interrogate an individual who was in the Columbia or the Murray County Jail with handcuffs on in a closed room with the door locked, and interrogate her about consistency or about the nature of the crime and labeling these two individuals. And then they brought up the names of these individuals before they testified. And in at least one of these interrogations, the co-defendant asked for an attorney and was continued to be interrogated. However, this does not, we did come up on the issue of standing, since both of those individuals were offered plea deals that they both accepted. Now, what I'm asking the court is, and I'm asking because I don't know, McElrath is still a new opinion in my, in at least my purview, that says that changes a lot of the nature of what we're doing here. Because it opens the door to systemic and reckless errors of the officer, not as much focused on the constitutional rights, just that it violated the Constitution. And in my brief, specifically paragraph 3, the exact question they asked in McElrath was, whether the error was isolated rather than recurrent. And question 2 is whether the error was a result of reckless disregard of constitutional requirements. Whoa, this evidence was obtained with reckless disregard of constitutional requirements. It did happen multiple times by multiple agencies who did not involve the chain of command and should definitely go towards the reliability of the evidence.
Well, Mr. White, isn't that an argument for another day?
Yes and no. All right,
How?
I agree with you that it would be an argument for another day in its entirety. But when we go back to Thomas and Hughes, those were both based off of lawfully obtained evidence. So there would be a distinction between those matters and this matter, because we have more of a corrupt pool here. As far as, fruit from the poisonous tree, these roots are dirty, right? And that wasn't factored into Thomas or Hughes when they made their decision. And I think that those would have been relevant factors to those decisions, because obviously you're not going to go with the reliability of illegally obtained evidence by a police officer on multiple occasions. That probably shouldn't make it to trial, in my opinion. However, all kinds of things are tried. So if all of the evidence is illegally obtained, and that's the proof pudding you got, then the proof pudding over here in Thomas, it was all lawfully obtained evidence. There was no challenge to that, or if it was challenged, it was ruled upon, etc. I didn't get into too much of the trial procedure of Thomas, but I didn't see anything about illegal evidence in there, illegally obtained evidence. Well, then those are two separate piles of evidence here, Your Honor. And I don't know how you can make a ruling based on one where things were done right versus one where things were done wrong. I think that there would be an inherent predicate factual distinction between those two matters. So if it's illegally obtained evidence, and Thomas says that lawfully obtained evidence, by refusal to admit or state anything on the record leading to the legality of the evidence, I believe the presumption would be that it was lawfully obtained evidence or reliable evidence, which is what allows you to change the corroboration rule. And I'm reading in some context here that's not explained in the ruling, but I don't think it's that extravagant of an extrapolation here to go to that point, because of the nature of, eyewitness testimony is already highly suspect on reliability. The court relies on it because it has to. But cases get overturned because of eyewitness testimony. We already heard one earlier today about eyewitness testimony and the conflict between the date of and the date of trial. They didn't remember anything. Yeah, it's half of your cases today are about eyewitness testimony, essentially. So I do believe that is a predicate distinction between the corroboration rule of Thomas and the corroboration rules required for my client to get a fair trial under the two beautiful constitutions, the bedrocks of this court, the federal and state constitution, state of Tennessee constitutions, because those were top 5 issues. all right? And, or top 10 issues if you can, the state. But these are inherent issues in the criminal justice system. These are bedrock issues that would affect the credibility and admissibility of evidence. And the entirety of what we're arguing is whether or not they need to corroborate this illegally obtained testimony, which I think is a case of first impression, because I'd searched and I couldn't find any other cases about that, at least not in this jurisdiction. I know the Ninth Circuit has some rules where you can have standing to challenge constitutional rights of co-defendants, but I don't believe anything's come out in the Sixth Circuit or in the state of Tennessee about that. Because it's always been a long-standing rule that you had to have standing to a challenge because they're your individual constitutional rights. But then once the court adopted Herring and introduced McElrath, it changed the nature of the game, because it's talking about the systemic error of law enforcement, all right? If they're not tracking their warrants properly, they shouldn't be able to use them to arrest people. If they're recklessly violating the Constitution, they shouldn't be rewarded by having that case go to trial. They should be reprimanded. They should be retrained. They should be, and reinforce the bedrock foundations that makes this America instead of another country. If that answers your question, Your Honor. It's the best I can do.
It did and then some. Thank you. My point is, if you're correct on this argument, you can make it another day.
Yes.
If we decide the trial court was incorrect here.
Yes.
There's nothing about that ruling that I believe would prevent you from making the same argument on another day.
But at what cost, Your Honor? Because if we go back and we have an unfair trial that's later deemed an unfair trial by the same tribunal, we're still preventing my client from having a fair trial on the front end, all right? And we're wasting a lot of government resources. We're wasting a lot of people's times. We're wasting citizens' times, because we've got to find 12 citizens in Hickman that aren't related to anybody here or anything else, and have them listen to all this illegally obtained evidence, which also it works against the entire court system, because it underlines the bedrock foundation that that the police, not you guys, but that the police force is out there doing it right, doing it the American way. This is more the secret police way than the American government way. So it does come with inherent damage to the court system. It does come with inherent damage to the police system. It does have inherent damage to all these different entities that we rely on the validity of in which to keep our society from falling into bedlam, Your Honor. But no, there's nothing preventing me from raising the argument after the trial. Well, gentlemen, if there's nothing else, I'll turn my time over to the state. Thank you.
Your Honors, I don't have much more to add. Judge Easter, I think you're right. And I think co-counsel kind of conceded there at the end. There's nothing that would prevent them from raising some of the evidentiary issues on direct appeal following any convictions that take place after the course of this trial. Just to respond to Mr. Bates's point about the state arguing in a pretrial proceeding that there would be no prejudice, because even under the old accomplice corroboration rule, that the requirement for corroboration was pretty minimal to come forward with some other proof to corroborate the accomplice testimony. And I acknowledge that point, and there's a little irony there, but this is still an important issue that this court needs to address, because there could be other cases, right, where the prosecution had commenced, but the trial had not commenced at the time of the Thomas mandate. So this court's holding is certainly going to bring some clarity to the extent there wasn't already that from the Thomas opinion. So we would ask this court to reverse the trial court's order on this jury instruction issue and not reach the other issues raised by the defendants in this appeal. Thank you.
All right, thank you, General. That's all the cases for the morning docket, is that right?
Yes, Your Honor.
All right, we'll be in recess till 1:30.
All rise.